वो कानूनों का मध्य बिंदु है कानून बनाने का। वो अंग्रेज शासन को मजबूत करने की दृष्टि से कानून बनाए गए थे। अंग्रेज शासन की रक्षा करने के लिए कानून बनाए गए थे और उसका उद्देश्य दंड देने का था, न्याय देने का नहीं था।
Good evening, viewers. I'd like to welcome you to my channel, De Facto with Naomi. Before seizing the day, let's have a look at India's proposed criminal law legislations. We'll be diving straight into what the new versions of the IPC, the CRPC, and the Indian Evidence Act look like. For the sake of a better understanding and ease, I intend to make it a three-part analysis, with the first video comprising of the current status, the current context, the rationale for these laws, and the provisions of the first bill, that is the Bharatiya Nyay Sanhita bill. Part 2 shall consist of the bills that will replace CRPC and the Indian Evidence Act, and very briefly we will also look into the limitations of the three bills. In Part 3, हम IPC के Section 124A को analyze करेंगे and will compare and contrast it to the new avatar of the BNS Bill 2023, that is Section 150. In Part 3, we will delve into what the opposition claims and the Government of India stand regarding the proposed legislations. ये important भी है और relevant भी. इस देश के आम नागरिक को पता होना चाहिए कि जब किसी चीज़ का politicization होता है तब ultimately निकल के क्या आता है. Before we begin, allow me to take a minute for myself. Viewers, this is my first video and I ardently request you to please like, share and subscribe to my channel. Also, please watch this video till the end, because as the old saying goes, incomplete knowledge is a dangerous thing, जिसको संस्कृत में कहेंगे अल्प विद्या भयंकरी. Now, without wasting a single nanosecond, let's begin with the current status of the three legislations. पहली बात तो ये that the three bills have currently been introduced in the monsoon session and not enacted. They are likely to be enacted in the winter session of 2023, pending a review and revision by MHA's Parliamentary Standing Committee, which will be headed by BJP's Rajya Sabha MP and former UP DGP Brajlal. इस कमिटी को हेड कौन कर रहा है ये रेलेवेंट इसलिए भी है because literally the entire spectrum of media in the country is reporting that nothing is known about the committee that is being set up for the purpose. अब हम इन थ्री बिल्स का बैकड्रॉप समझ लेते हैं. The Prime Minister set the ball rolling on 15th August 2019 from the ramparts of the Red Fort. He committed to rid India of the colonial legacies and relics in both letter and spirit before 2047, that is India's 100th year of independence from the British rule. An obvious step in this direction is to do away with the crown-centric laws. So इसको अचीव करने के लिए in May 2020 MHA ने एक कमेटी बिठाई under Professor रणबीर सिंह. उसका पर्पस था to review the criminal laws in India from start to finish. And the three laws now introduced in the Parliament have been tabled as a result of the recommendations of this particular committee. अब इन तीन laws का context समझ लेते हैं. On the last day of the monsoon session, that is on 11th August 2023, the three laws were put forth by Home Minister Amit Shah for the perusal of the House of People. The Bharatiya Nyay Sanhita or the Bharatiya Sakshya Adhinayam 2023 will replace the 163-year-old Indian Penal Code 1860. Bharatiya Nagrik Suraksha Sanhita will replace the 125-year-old Criminal Procedure Code 1898. And the Bharatiya Sakshya will replace the 150-year-old Indian Evidence Act 1872. और समझने वाली बात है कि गवर्नमेंट इन बिल्स को ला क्यों रही है. Why do we need a change in our criminal laws? Because the government seeks to de-anglicize the criminal laws of our nation. Because during the past 77 years since Indian independence, we have brought no major changes to these laws. Secondly, the three laws have been brought in to keep abreast with the changing conscience of our society, the evolving nature of crimes, and to deal with those crimes more concretely and effectively. Thirdly, these three laws also need to be seen in the form of a consolidation and organizational exercise. Unlike the erstwhile laws, where the provisions related to, for example, crimes against women and children or organized and petty crimes were scattered, these three laws seek to codify the specific crimes under dedicated chapters. And fourthly, the legislature is not attempting to breathe a new life into the colonial era legislations, but instead proposing to enact wholly new and comprehensive legislations to deal with crimes and criminals. अगर हम ये कर पाएं, not merely in what is being claimed, but also in what translates into reality, it will be a huge achievement. अब the most interesting bill of all, the भारतीय न्याय संहिता बिल को देख लेते हैं. ये बिल आईपीसी को रिप्लेस करेगा. It introduces 8 new sections, repeals 22 provisions and amends 175 existing provisions. In this bill, the offence of adultery under section 497 has been repealed after the Supreme Court judgment in Joseph Shine versus Union of India 2018 and will not feature in the BNS. The punishment for crimes against women and children have been made more stringent. For all types of gang rape, 20 years of imprisonment or life imprisonment has been prescribed. For the rape of a minor, death penalty has been prescribed. Additionally, in the new bill, it has been made mandatory for courts to give their verdict on rape cases within a stipulated period of 30 days as against the erstwhile 60 days period. Also, for the first time under clause 101, punishment for mob lynching, that is murder committed by a group of 5 or more persons, has been prescribed. Mob lynching will be punishable with capital punishment, that is death penalty, or not less than 7 years of imprisonment or life imprisonment. A move that the Home Minister says has been taken after carefully studying many such crimes in the recent past. Other than that, in accordance with Section 19 of the Prevention of Corruption Act 1986, the Supreme Court judgment in the Vineet Narayan case of 1997, the bill has made it mandatory to sanction or deny prosecution of the civil servants within 120 days of application, or the same would amount to deemed approval. The bill also has provisions to punish absconding criminals who would be tried and sentenced in absentia, meaning that the criminal needn't be physically present while he is tried and convicted. In terms of Section 109 and Section 110, ये important है कि पहली बार organized crimes and petty organized crimes have been accorded their specific sections, and both sections borrow heavily from Maharashtra's law. मतलब हम एक स्टेट लॉ से बोरो कर रहे हैं. द लॉ इज कॉल्ड MCOCA और द महाराष्ट्र कंट्रोल ऑफ ऑर्गेनाइज्ड क्राइम्स एक्ट, first enacted in 1999 and is known to be the act that heavily cracked down upon crime syndicates in Maharashtra. Now, what constitutes petty crimes? These are crimes like ATM thefts, including card skimming, leaking of exam papers, or the selling of public exam papers, theft through shoplifting, car theft, domestic and business theft, trick theft, cargo theft, theft of personal property, organized pickpocketing, snatching theft, illegal selling of cinema tickets, and the like. It's worth noting that the erstwhile IPC did not have specific provisions to deal with these offences, and एक broad category theft के अंतर्गत इन सारे crimes को deal करा जाता था. अब एक बार क्राइम्स अगेंस्ट वुमेन से रिलेटेड प्रोविजंस को भी ब्रीफली देख लेते हैं. A new provision, that is Section 69, has been inserted with 10 years imprisonment for sexual intercourse with a woman on the false promise of marriage. Again, ये भी अगर आप करंट अफेयर्स को फॉलो कर रहे हैं, ये पिछले 1-2 साल से बहुत डीपली कंटेस्टेड टॉपिक रहा है. Other than that, video recording of statements of victims has been made compulsory, alongside it being made mandatory for the police to inform the victim about the status of their complaint within 90 days of filing the same. Okay, so these were the goodies with respect to the women-centric laws. But one striking issue with the bill is that marital rape has still not been made an offence under the new bill. That is, sexual intercourse by a man with his own wife, the wife not being under 18 years of age, will not be considered an act of rape. This is one vital piece of detail that ought to have been included in the legislation, especially with the ballooning onslaught of pleas that the courts have been receiving to criminalize marital rape in the past few years. With this, we come to an end of this video. It was lovely talking to you. I'll see you with the next two legislations in the next part. Please stay tuned. Over and out.